I'm very honored to have been invited to join the OECD roundtable about criminalization of cartels and bid rigging conspiracies. I want to thank for that. Having read the very detailed and informative OECD Secretariat's background paper, I was wondering which additional contribution I could bring to this distinguished audience, in particular to the delegates. Given my current experience as a practitioner, even though I have an enforcer's background, the idea here would be to try to address some of the challenges that we as antitrust practitioners face on our day-to-day work when defending companies and individuals in countries with criminal enforcement. Bearing in mind the interaction between criminal and administrative proceedings, in particularly in regard to competition and other leniency programs. Hopefully, the delegates might find useful to hear about those challenges, as we know that enforcers are all the time trying to design the regimes and enhance the regimes to make sure that they work properly to attract parties for leniency or to attract parties to further cooperate down the road, and at the end of the day being able to identify misconduct in that situation. I'll try to tackle four main groups of challenges, and I'll talk about the misalignment of incentives between companies and individuals. I'll also mention the big challenge of coordinating between different agencies in countries where you have dual system, administrative and criminal separated, and also in relation to other agencies that protect other regulations. A third group the third challenge that we had relates to coordinating among different jurisdictions. And fourthly, I'll address some very practical issues that arise when dealing with countries with criminal enforcement. I think that the first and the main challenge at the end of the day when you have criminal enforcement really relates to the misalignment of the potential misalignment of incentives between companies and individuals. For companies, it doesn't really make a big difference if the sanction is criminal or administrative, if at the end of the day they would be subject to a fine. While for the individuals, they are the ones that really suffer the consequences of a criminal prosecution, as they would be the ones that could be potentially serving time in jail. As such, the perspective when facing a case really changes substantially in relation to whom you would be representing. It could be that in some cases interests are aligned, but that's not necessarily the case. So in countries where you do have, especially if you have dual systems of criminal administrative enforcement, the challenge is to vary in accordance to whom you would be representing and what are you trying to protect at the end. Is it the main goal to try to avoid prison, or the main goal is really to try to reduce fines? We could also have a situation where the key goal is avoid debarment, and the interaction with the authority that deals with that is not necessarily the criminal authority is the main driver. So again, the key point would be related to who would be the one that needs to be protected as first. It is true that in a large number of cases, conducts are identified in the context of routine internal investigations, and also in some cases relates to merger due diligence efforts. And if that happens, normally the company is the one that initially becomes aware of the misconduct, and it's not uncommon that the protection of the individuals would not be the main driver. But of course, taking into account the criminal impacts on those individuals is really key. And in that sense, I think the interesting question to be brought is criminal enforcement pushing for more investigations or not? And I'm not really willing here to get into the topic that was very well developed on the background paper that relates to whether individual charges should be applied and all the moral stigma around it. But the point here would be that on the one hand, we could say that having criminal enforcement could to some extent trigger more leniency applications. I would dare to make the question that would there be the same amount of leniency applications if there was no criminal liability for individuals in specific countries? I would dare to say that at least in Brazil, maybe that would not be the case. I think criminal liability is something that is an important issue taken into account in the context of leniency application. But that does not mean that criminal enforcement necessarily brings for more cooperation with the authorities, because if that could be true when leniency is available, on the other side of the coin, if criminal sanction is to be applied in addition to the administrative one, this may be to some extent a deterrent for individuals to cooperate if amnesty is not available. The individuals could be concerned to admit a violation, and if they are not totally comfortable of how this would be dealt by the other authorities, by the criminal authority, for instance. As such, the big challenge that we know that enforcers face to try to coordinate among the agencies is indeed key, and the interaction between the laws and the authorities is key. And this is what brings me to the second challenge that relates to the need to coordinate among different agencies within the same country. As I was saying before, in many countries, criminal enforcement is, you have a dual system that has criminal enforcement on the one side and administrative enforcement on the other side. And in those cases, it's important when we reach out to the authority for a leniency application or potentially for a plea agreement or a settlement at a second moment. And I know countries use the different terms of plea agreements, settlements, agreements, or things like that. But what I'm thinking here is really about cooperation when amnesty is not any longer available. It's very important for the individuals and the companies, and of course for the practitioners defending them, that they have all the information about how this interaction would work, how reporting and information to one of the authorities would be brought or would be used to the other one, so on and so forth. And this is also true not only between criminal and administrative authority, but also in relation to other authorities that could investigate the same conduct. So in terms of investigating bid rigging or fraud, sometimes other administrative authorities or different prosecutors could be in charge of those investigations, and in that situation is indeed key that coordination is done. Leniency might extend to some cartel-related criminal offenses in some jurisdictions, but the narrative may uncover other offenses that are not necessarily covered by the leniency application that would be done by before the competition authority or before the criminal authority addressing the competition issues. So again, knowing how this would interact, how this would play is indeed key, and this is a huge challenge that needs to be faced. There is a huge challenge in terms of needing to coordinate among different jurisdictions. That's the third challenge. And in that sense, you all know better than I do that different countries have very different regimes, and when advising a company and or an individual, it's key to understand to which extent information provided to authorities in one jurisdiction might set off risks of either criminal or administrative nature, or even relating to the possibility of damage claims in other jurisdictions. And this would also involve some very practical issues such as privilege, confidentiality, and so on. So even though clearly when defendants are cooperating with the authorities, they need to be very mindful of consistency across jurisdictions, be mindful about full disclosure, it's important that parties take care to be to make their narratives as fact-specific as possible in order to mitigate the risk that could have impact on a jurisdiction where leniency might not be available in comparable terms. So the need to coordinate between different jurisdictions is the third challenge I would mention. And lastly, I would mention some very practical issues that would arise, and I'm considering those practical challenges, and that would relate, for instance, to whether there would be joint or separate representation between the parties. Some countries have specific rules about that, some others leave this to the decision of the individual and the company. but it's a practical issue that sometimes take a lot of time, and having guidance on that and discussing this with enforcers is also an important point. Other big challenges, sometimes the threshold of evidence in the criminal administrative areas vary substantially, so you might have enough evidence to apply, for instance, for leniency before the administrative authority, but the criminal authority might think that that's not enough evidence. But if the administrative authority goes further on the investigation and other things arise, that could become in the future a criminal investigation. So again, it's an issue of trying to coordinate the different challenges among the different authorities. Likewise, the issue of timing and statute of limitation is another very practical issue. This is something that varies substantially across different jurisdictions and needs to be taken into account, along with the issues of jurisdictions that require oral disclosures, some others require written disclosures and things like that. That seems to be practical, but that can become a huge burden to overcome. And lastly, I would mention the issue of damage claims, for instance, that in some jurisdictions are a huge thing. And even though the company might be willing to not, for instance, disclose a conduct and sit and wait to see what happens just to avoid potential damage claims, and because potentially they could believe that there is not enough evidence for the practice to be uncovered, the individual might say, I do not want to risk going to jail, so I want to make the disclosure. So again, damage claims is another of the points that comes into play in that context. So that was basically it. I tried to address in my 10 minutes the main challenges that relate to the enforcement in countries with criminal sanctions, and at the end of the day, I think we are all the time going back to the key point that is key, that the laws and policies are designed by the authorities, aiming to reduce the uncertainties and make sure that the criminal sanctions, when they exist, they work for increasing the enforcement. And for that purpose, transparency, coordination between the authorities and predictability is key, and that is particularly true in cases where you have dual systems or where you have different authorities interacting among itself.